responding to a specific piece of business is itself relevant as to whether or not we should attend to that business. So in my view, the issue of relevance is misguided. Thank you.
Thank you.
Point of order?
Point of order, Mr. McKinnon.
I don't think the issue of relevance is ever misguided.
Thank you, Mr. McKinnon. Mr. Genyas, continue, please.
Yeah, the principle of relevance is important. It is possible for it not to be applicable in a particular case, I think, and that is this particular case. Since the item of business we're proceeding to is about the prison transfer, and our position is that we will insist that those families, their testimony be honored with a substantial report to Parliament. That is our firm line. And it's important for all members to know this, that when we've taken the time to have these hearings with the families and their representatives, the committee must report to the House. So members can reflect on whether or not they will permit that to happen and the consequences of that. We will insist that the work done on the Bernardo transfer lead to a report to the House. And at this point, having the government members, at least, sit on this issue for months and months and months since the fall, we are insisting on that as part of our amendment to the subcommittee agenda, which I am proposing that we proceed to.
Rappel au règlement,
Chair,
Monsieur le Président.
Thank you.
Point of order. Thank you, Chair. I just want to clarify what I said before when I talked about the performance of the Conservative Vice Chair in the committee, but that was my mistake. I wasn't referring to the Vice Chair. I was referring to the Shadow Minister. The Vice Chair was not present at that meeting. By the way, I appreciate his work very much.
Mr. Chair?
Yes.
Okay, thank you. If deliberations are supposed to be in camera, then they're supposed to be in camera, and if we're going to nitpick about who said what, and the nature of the representations as implied by Ms. Michaud, then we are getting perilously close to discussing what was said in camera, and I don't think it's appropriate for somebody to say, well, this is what happened in camera, when people can't actually discuss that. So I would just ask that that those types of communications be refrained from. Thank you.
Continue, Mr. Genyas, please.
Yeah, thank you. I do think Mr. Caputo's point is a crucial one, that he's not able to respond to what he said or didn't say in the context of that meeting, and so implications about people's positions are gravely unfair. They may be accurate or they may not be. I wasn't there, but it's unfair to sort of have the conversation about something that happened in private that we're prohibited to discuss. On the issue of the prison transfer, I'm now going to proceed to read this letter that I was referring to. It says, "We are counsel for the French and Mahaffey families and the estates of Kristen French and Leslie Mahaffey. As you know, the families were shocked by the news that Paul Bernardo was transferred from a maximum security prison, Millhaven, to a medium security prison, La Macaza, I'm sorry if the pronunciation is incorrect, without explanation or advance notice. They have asked that I write this letter to you. Thank you for taking the time yesterday to speak to Donna French directly. That was very much appreciated. This said, a serious public discussion is necessary. Emphasis, a serious public discussion is necessary. And hopefully this letter will continue that discussion. Accordingly, the families have instructed us to write this letter to you as an open letter to the public as well. The letter, by the way, is addressed to Commissioner Kelly, but it is an open letter as the text I read just says. As you know, the letter continues, as you know, Paul Bernardo was convicted of the murder of Leslie Mahaffey and Kristen French and sentenced to life in prison. He was declared a dangerous offender. In declaring Mr. Bernardo a dangerous offender, the learned trial judge, the Honorable Patrick Lesage, ACJO,
Point of order.
as he then was, made the following.
We are once again ranging way far afield from the matter of whether we should go to the matter of business to discuss the subcommittee report. We discussed all these matters previously in this committee, and in particular in those studies. They do not help us make the decision of whether we should go to this order of business. And I would really encourage Mr. Genyas to, if you recognize the importance of dealing with these matters, that we actually get to it, to do it.
Thank you. Mr. McKinnon?
Okay, thank you, Chair, for giving the floor back to me. I just wonder if some members don't understand what relevance is. Like the motion is that the committee resume debate on the report from the subcommittee on agenda and procedure and the amendment of Mr. Jennis, provided that once debate has been resumed, Mr. Caputo be deemed to have the floor. So the motion before us is a resumption of consideration on the report from the subcommittee on agenda and procedure and the amendment. And the amendment is centrally about the question of whether or not this committee should report to the House on the transfer of Paul Bernardo. Now, if the subcommittee report is not considered, then we will not have an opportunity to advance that concept. If the subcommittee report is considered, that is, if we return to that item, then we will have an opportunity to consider and adopt the provisions associated with the prison transfer in that amendment. So as I said earlier, not only is it within the ambit of relevance, it is centrally on the core of relevance. It is the target of relevance. It is the issue at hand. Oh, yeah.
Continue, and we'll try to refrain from the parliamentary procedures. Just continue with your whatever you're...
Yeah, okay. Sorry, I thought you were chasing me for being too close to the mic, which was also the case, I realized, and I apologize. Okay, so continuing with the letter I was reading, the Honourable Patrick Lesage, ACJO, as he then was, made the following findings. I dare say that all of the people in Ontario, and perhaps Canada, have felt the revulsion of the crimes which you have committed, Mr. Bernardo. The French and Mahaffey families are the ones that suffered.
Point of order, Mr.
Relevance.
McKinnon.
This is not relevant to the question at hand.
Yes, it is.
Continue, Mr. Junius.
Thank you, Chair. The French and Mahaffey families are the ones that suffered the pain and interminable suffering. The Associate Chief Justice concluded that Mr. Bernardo
Point of order.
should spend...
Once again, this is absolutely not relevant to the point at hand. If Mr. Jennis wanted us to actually deal with these matters, he would let us vote on his motion, and conceivably we could actually get to them. But talking for several hours on miscellaneous matters tangentially related to the point at hand is not productive.
Thank you, Mr. McKinnon. Mr. Junius, could you continue?
Thank you. The French and Mahaffey families are the ones that suffered the pain and interminable suffering. The Associate Chief Justice concluded that Mr. Bernardo should spend the rest of his natural life in prison and that he had, quote, no right ever to be released, end of quote. His Honor held that, quote, everyone here, everyone in this courthouse, everyone in this city, everyone in this province, everyone in this country knows that you are a dangerous offender. Justice Lesage further stated that Bernardo's crimes were of such a brutal nature as to compel the conclusion that your behavior in the future is unlikely to be inhibited by normal standards of behavioral restraint. Again, such a brutal nature as to compel the conclusion that your behavior in the future is unlikely to be inhibited by normal standards of behavioral restraint. The behavioral restraint that you require is jail. You require it, in my view, for the rest of your natural life. You are a sexually sadistic sociopath. The likelihood of you being treated is remote in the extreme. End of quote. Mr. Danson continues in this public letter. Justice Lesage was considered to be one of the most distinguished, skilled, experienced, and compassionate trial judges in the country. Based on the overwhelming expert evidence before him, the Crown proved beyond a reasonable doubt that Paul Bernardo was a sexually sadistic psychopath and murderer, requiring the dangerous offender designation. Evil is too kind of a word for Paul Bernardo. The powerfully considered words and judgment of Justice Lesage clearly was not considered in the decision to transfer Paul Bernardo to a medium security institution. nor were the findings of the Parole Board of Canada at Mr. Bernardo's 2018 and 2021 parole hearings. In its decision of October 17th, 2018, denying Paul Bernardo parole, the PBC noted inter alia that the, quote, psychiatrist concluded that you, Bernardo, have deviant sexual interests and you met the diagnostic criteria for sexual sadism, voyeurism, and paraphilia, not otherwise specified. Additionally, you demonstrated traits of a personality disorder that the psychiatrist opined met the criteria for narcissistic personality disorder. He further opined that you met the requirements for a diagnosis of psychopathy. The psychiatrist was pessimistic about your treatment options. The PBS also noted that other psychiatrists concurred with previous diagnoses of sexual sadism and psychopathy, thereby representing a significant risk for reoffending. They felt the treatment would be unsuccessful given Mr. Bernardo's personality characteristics and sexual pathology. And Mr. Danson's argument is clearly very well referenced with the expertise of others. And he continues, the PBC noted in its October 17, 2018 decision that the spousal assault risk assessments confirmed that Mr. Bernardo was at a high risk for violence against a domestic partner. The board noted that Mr. Bernardo justified inflicting pain, including forcing painful, unwanted violent intercourse on his victims to gain dominance, control, and compliance. Bernardo was found to be callous, glib, grandiose, cunning, deceptive, manipulative, and a liar. Further, the board found that Bernardo had a complete lack of understanding of the impact of his offending and violent and sadistic behavior. Psychopaths like Paul Bernardo know exactly what they are doing. Bernardo fully appreciated the nature and consequences of his actions. The problem was that he enjoyed it. Bernardo had an uncontrollable need for exercising power and control over innocent children and women with unspeakable sadistic brutality. He got a thrill out of terrorizing his victims, and inflicting unspeakable pain and suffering on them. He videotaped sadistic attacks for his personal entertainment. And the letter continues, in the face of this, CSC transferred Mr. Bernardo to medium security. Based on all of this evidence, which should have been before the relevant authorities, the decision was nonetheless made to make this transfer. And this was a subject that the committee engaged on and which the committee should report on. The letter continues. At both parole hearings, the PBC, the Parole Board of Canada, found that Bernardo showed no remorse, insight, or empathy. At his June 22nd, 2021 parole hearing, the PBC essentially adopted the findings and conclusions reached at the previous hearing, including sexual sadism, narcissism, personality disorder, and psychopathy. At the June 22nd, 2021 hearing, PBC confirmed on August 17, 2015, psychiatric risk assessment, which concluded that Paul Bernardo continued to represent a high risk of sexual and violent behavior. The clinician noted that you, Bernardo, still met the criteria for sexual sadism and narcissistic personality disorder, and continued to display psychopathic traits such as arrogance, entitlement, and lack of empathy. It was this psychiatrist's opinion that these conditions were not treatable. These conditions were not treatable. The PBC also referred to the most recent psychological risk assessment dated April 28, 2020, which confirmed that Mr. Bernardo had limited empathy and that it is beyond debate that you, Mr. Bernardo, are a high-risk offender, and that the available psychiatric and psychological assessments concluded that you remain at a high risk for sexual offending. The simple truth is that there is no cure for sexual sadism and psychopathy. The psychiatrist who testified at Paul Bernardo's dangerous offender hearing and who provided a subsequent report a decade later to PBC, was correct when he testified that Paul Bernardo was not treatable. We urge you to listen to the audio recordings of both Paul Bernardo's parole hearings. They are chilling and deeply disturbing. He is Exhibit A as he speaks about his unspeakable crimes, talk like normal people talk about the weather. This man, the letter says, is a monster devoid of even a scintilla of humanity, decency, remorse, or empathy. At the same time, he is skillfully cunning and manipulative. Given the opportunity, he will offend again, violently, brutally, and sadistically. The recordings of Mr. Bernardo's October 17, 2018 and June 22, 2021 parole hearings should be released to the public so that Canadians can judge for themselves the reasonableness of CSC's decision to transfer Bernardo from a maximum security to a medium security facility. Let Canadians, whom you serve, judge CSC's justification for the transfer against the objective evidence. Justice must be carried out in a transparent manner, not in secret. Respectfully, I am not interested in abstract theoretical discussions about possible rehabilitation of someone who can never be rehabilitated. Even as recently as Mr. Bernardo's June 22, 2021 parole hearing, 30 years after the murder of Leslie Mahaffey and 29 years after the murder of Kristen French, Mr. Bernardo remained unchanged. It has only been 2 years since his last parole hearing. No one could suggest that in the last 2 years, Mr. Bernardo has been able to effect a miraculous rehabilitation within a maximum security federal penitentiary, which he could not achieve in the first 28 years. This is not a subject that I am comfortable discussing for a variety of personal reasons, but I cannot help but to reflect on the content of the Bernardo Homolka videotapes, which unfortunately are embedded deep in every fiber of my soul and continue to haunt me. No human being can view the images and hear the utterly unspeakable acts of sadistic brutality on two defenseless, beautiful teenage girls and not conclude, as did Justice Lesage, that Mr. Bernardo must remain in a maximum security federal penitentiary for the rest of his life. While principles of rehabilitation are critical and apply to 99% of the federal prison population, they do not to the remaining 1%, like Paul Bernardo, who are beyond rehabilitation. The letter continues, the system can neither pretend nor play games. Absent a compelling explanation, it would appear that CSC is trying to assist Mr. Bernardo with his parole eligibility by cascading him through the system from maximum to medium and then minimum security and then out the door on parole. Now, if I can pause in the letter, Mr. Speaker, to make one point that I think is just very important in this letter and in the issue of the prison transfer. That the prison transfer issue is important in and of itself because it reflects a false and dangerous assessment of the security risk associated with Mr. Bernardo, and it creates dangers to others in the prison population. It carries with it a variety of other risks in the immediate context of the prison transfer. But it is also a concern of Mr. Danson and the families that he represents, that the transfer from maximum security to medium security can be part of a process of trying to demonstrate rehabilitation that leads then to further transfers and subsequently to parole. And of course, it is a critical matter based on the evidence that has been presented here at this committee and in this letter that process not be undertaken. So the sounding of the alarm by the families and their representatives, it reflects not only a concern about the specific issue of the prison transfer, but a concern about where this could lead, about the fact that we have seen increasing instances of people who are bailed or paroled beyond all logic and who reoffend violently against other members of the population. And that is why this issue of completing the work on the prison transfer issue and reporting to the House on it is so important to Conservatives. But I'll continue the letter, Mr. Chair, that even the letter continues, even under the sentencing principles stated in Section 718 of the Criminal Code of Canada, the first principle is punishment, to denounce unlawful conduct and the harm brought to victims or to the community that is caused by unlawful conduct. The second principle is to deter the offender and other persons from committing offenses. The third principle is to separate offenders from society where necessary. While the fourth principle is to assist in rehabilitating offenders where realistic, the first three sentencing principles prevail. As questioned above, what has Mr. Bernardo achieved, in the last 2 years that he was incapable of achieving in the previous 28 to 30 years? There is no cure for psychopathy. Other sentencing principles include increasing a sentence to account for any relevant aggravating circumstances related to the offense or the offender. See Section 718.2 of the Criminal Code of Canada. The aggravating circumstances for Mr. Bernardo are endlessly horrific. I wish to address the CSC news release, where it is stated that prior to the transfer and immediately after, CSC provided information and updates to all registered victims about the offender. As counsel for the families and Kristen and Leslie through their estates for the past 30 years, I can advise that I was not informed of the transfer prior to it happening. When I was notified, it was a fait accompli. The transfer had already been completed that day. And Chair, this is truly incredible to me that there was only information provided to the families after the transfer had already taken place. And we know, and as I'll get to, that information was provided to government prior to the affected families getting this information, and it was presented only to the families as a matter already complete. And this explains really the pain and the concern that we see in their response that we heard here, and that drives the need for us to respond to that by reporting this matter to the House, by unearthing this report that some on this committee would rather see buried. One consistent trend in this issue is information being buried by people on the government side. The families were not informed until after the fact about the prison transfer. The government actively resisted letting family members testify, and we had to use all of the procedural tools in the book to allow those hearings to take place. The government opposed a private member's bill we put forward by Mr. Generou regarding the prison transfer issue. And now we have a situation where the committee has not reported because potential report and work on that report is being buried by some members of this committee. And this is why we want to bring sunlight to this issue, open discussion, so that we can see what's happening, we can report on it to the House, and we can get to the bottom of the issue. And we can make substantive recommendations that reflect what we heard from the families. I'm very struck by what Mr. Danson says in this letter about it being already done when the families were told. The letter continues. When notified of the aforesaid statement, I first tried to access my own telephone records and messages. May 29th, 2023 was an exceptionally busy day for me, and I was not available in the morning. I see that a completely routine, absolutely nondescript voicemail message was left for me at 9:06 a.m. A second voicemail was left for me at 1:48 p.m. that same day, also nondescript, literally, quote, that CSC had some information for me. I have been unable to confirm my outgoing calls for May 29 as of this moment, but my recollection is that I returned the call relatively shortly thereafter. At this point, I had learned that Paul Bernardo had been transferred from Millhaven to Lamakaza. None of my relevant questions could be answered due to Mr. Bernardo's privacy rights. I did express my objections, but at the same time, I recognize that the person I was speaking to was just a messenger doing her job. I then contacted the families to determine if they had been notified of the decision prior to Mr. Bernardo being transferred from a maximum security penitentiary to a minimum security penitentiary. By prior to the transfer, I do not mean the actual day of the transfer or while Mr. Bernardo was en route. Obviously, that would not constitute prior to the transfer. To be credible, the advance notice would have had to have occurred days before or at the latest the day prior. And I might interject that the day prior clearly would not be acceptable. But it wasn't even the day prior. It wasn't at all in advance. The letter continues, yet apparently the Frenches were advised on the morning of Mr. Bernardo's transfer without any explanation. That is, they were not advised that he was being transferred from a maximum security penitentiary to a medium security penitentiary. Rather, in the morning of May 29th, 2023,
Point of order.
they were advised that
Point of
Mr.
order.
Bernardo was...
Mr. McKinnon, point of order, please.
Thank you, Mr. Chair. I'd like to bring the attention of the chair to the note, to the fact that the time allocated for this order of business has expired, and that we should go to release the witnesses and go to in camera as specified in the agenda.
On that point of order, Chair, if I can just clarify for the member, as I said earlier, I have no objection to releasing the witnesses, but the rules of the committee are that when a matter is being is being debated, that matter continues to be debated until the meeting is adjourned, the item is adjourned, or the item is disposed of. But I have no objection to releasing the witnesses. That's what I said that I think is a while ago.
So in saying that, Mr. Genius, you want to continue?
Yes, I mean I'm midway through reading this letter. Yeah.
Thank you.
definitely, yeah.
Continue.
Okay, just to Mr. McKinnon's point, it is at the end of the time that had been the witnesses had single their availability. So if the witnesses would like to go, I don't object to that. But if they'd like to stay, I don't object to that either.
We could ask for unanimous consent to release the witnesses. Good. Thank you so much. With apologies.
Sure.
Well, we're going to just pause just until the witnesses wrap up. Mr. Genius, please.
Pausing without suspending? Or?
Just pausing.
Okay, all right. Mr. Chair, it seems the chat is going on. I'm happy to continue, or I'm happy for us to suspend, but I don't understand where we are right now.
While we're in this, Mr. Genius, and maybe as a privilege of the chair, I want to let members know that based on the last two meetings, that I will be asking or requesting a 30-day extension on CS210, and I think it's important that we follow through on our
point of order, Chair. You cannot do that unanimously, and you know that, and so does the clerk. That those extensions have to be adopted by the committee. We have in our subcommittee agenda a reference to that extension. We have not proposed an amendment to that, but we are going to insist that a report be done on Mr. Bernardo's prison transfer as part of that package. So, I think you know that you can't unilaterally report to the House on a matter. The committee does not consent to that.
Yes,
Thank
okay,
you.
let's continue.
Thank you. All right. Maybe just to respond to some of the context, the subcommittee report with the amendments we're proposing is a package. If there are pieces of that subcommittee report that we have left unamended that members like and want to see, they can support. They can indicate their support for the amendment, and perhaps there can be offline negotiations around that. But our position about the report on the Bernardo transfer is very clear, and I want members to understand exactly why that is important to us.
I do believe we should be in camera at this point per the agenda. I wonder if I can do a dilatory motion to move.
You can't. You don't have the floor. You
camera?
can't move a dilatory motion when you don't have the floor.
Well, I'll let the chair.
Okay. Just on the point of order, I think members know that you can't move dilatory motions on points of order. You can move a dilatory motion if you have the floor, but you can't when you don't have the floor.
Mr. McKinnon, continue, Mr. Genius, please.
Thank you. Thank you very much, Chair. All right, so I was in the process of reading a letter from Mr. Danson explaining the really shocking circumstances around the prison transfer of Mr. Bernardo, the lack of information provided to families, the cover-up I think we saw within the system in relation to this. The
Point
letter
of order,
says,
Mr. Chair. Ms. Genuis used the word cover-up, and I just wanted, for the purpose of the discussion, whether he was reading the letter or whether that was his assumption, that was his words, because he said he was reading a letter, but then he used the word cover-up. Just want to be clear so that we have clarity for the record.
Mr. Genius, could you clarify?
Sure.
please?
Yeah, I'm happy to. That is my own comment. Absolutely. I have been reading the letter and at times interjecting some comments, and I hope it will be clear in the record which parts are quotation and which aren't. But I will try to specify clearly. You know, quote in, quote out. I'm about to resume the reading of this letter, which describes the circumstances in terms of what families were told and not told, when, etc. And I think it's. I think this is Garnet Janis talking. I think this is very shocking content and would be deeply disturbing to Canadians, as we've seen in the public response to these matters already, especially from the families and those that are part of the communities that were most affected by these crimes. The letter, the text of the letter, continues as follows. Yet apparently the Frenches were advised on the morning of Mr. Bernardo's transfer without any explanation. That is, they were not advised that he was being transferred from a maximum security penitentiary to a medium security penitentiary. Rather, in the morning of May 29, 2023, they were advised that Mr. Bernardo was being transferred, and by early to mid-morning, they were told that the transfer had been completed. Ms. Mahaffey was left with the distinct impression that the transfer had already taken place, or at least was imminent. Now, the letter continues, regardless, the decision had been made. It was a fait accompli, and there was nothing anyone could do about it. The decision to delay informing myself as counsel and the families until the day of the transfer, and while the transfer was in progress, is, with respect, troubling. Given my role as counsel for the past 3 decades, it was incumbent of CSC to relay this critical development to me in a timely manner so that I could inform the families. This was not regular administrative news. A development of such pivotal importance came as a shock to the families and ought to have been processed through counsel. Had anyone considered that this transfer was done just over 2 weeks prior to the anniversary date of Leslie Mahaffey's abduction and murder?
Please.
A couple points. If Mr. Genuis is popping his P's right into the microphone, I was wondering if he could also interject into his remarks if this was truly the issue he claims it is for the Conservative Party. Why, when Ann Kelly was here, they brought a motion on the carbon tax, if this was a matter of top priority for the Conservative Party. She was here just a couple months ago. Why the hypocrisy? And why using this to filibuster a bill they claim to support? I'm just curious. It's my community.
Thank you, Mr. Biddle. Mr. Genius, continue, please.
Thank you, Chair. So on a number of points to respond to that, Conservatives have insisted on and were able to give the families an opportunity to appear. Now, he mentions Commissioner Kelly, and of course we've asked the Commissioner important questions in relation to this. There have if the member was heard, and now he's welcome to hear my response. I suspect he's distorting the flow of that particular meeting. I wasn't there. Of course, look, if Mr. Biddle has another point of order, he can raise another point of order. Thank you. But Mr. Biddle had strong views on crosstalk previously. And his views have, it actually was on.
Point of order,
it was
Mr.
turned on
Chair.
and it was turned off. But I'm happy to continue
Point of order,
if there
Mr.
won't be
Chair.
interruptions.
Mr. Biddle and Mr. Genius, please get back to what you're talking about. I have a point of order from Mr. Nahama.
Thank you, Mr. Chair. So, Mr. Biddle raised a point of order. Mr. Genuis asserted he wasn't there. He asserted that what Mr. Biddle said happened didn't actually happen. So perhaps we could suspend and look at the blues to see what actually happened in that meeting, so that we have confirmation that indeed, as Mr. Biddle says, a carbon tax motion was brought during Ann Kelly's testimony. If that is in fact what happened, then it'd be important for everyone who is watching this, for everyone in this committee, to be aware of the facts. Given that neither Mr. Genuis nor I were there, perhaps we can all have the same basis of facts, and perhaps that we could suspend and the clerk could look at the blues from that meeting and confirm for the committee what actually happened.
Thank you, Mr. Mohammed. Continue, Mr. Genius.
Thank you, Chair. I did not definitively assert regarding what did or didn't happen in the meeting, but I said I highly suspect that Mr. Biddle is presenting let's say an account of the facts that differs slightly from a more objective account of the facts. But if the member wants to provide evidence to the contrary, there are. I can say that Conservatives have, of course, asked important questions to the Commissioner, but the core issue we're talking about at this point is actually the families being heard and the families being included. It's about the testimony and the experience of the families.
Point of order.
Not.
As a celebration of futility, let me once again raise the point of relevance. I would also note, as further futility, that the matter that Mr. Genis is striving so hard not to get to a vote on, to take us to an order of business, we would be actually in that order of business right now if we were able to proceed with the agenda.
Thank you, Mr. McKinnon. Mr. Genius, continue, please.
Thank you, Chair. I will continue with the point. I'm sort of confused about what point government members are trying to make here, but I think I'll just go back to the argument that I was making, which I understand would be your preference as well, Chair, which is that the committee.
My preference.
Oh, I'm
thank
sorry.
you.
Sorry. Yeah, fair enough, Chair. You are discharging your role as Chair with neither fear nor favor. The letter continues. Ms. Mahaffey was left with the distinct impression that the transfer had already taken place, or at best, was imminent. Regardless, the decision had been made. It was a fait accompli, and there was nothing anyone could do about it. The decision to delay informing myself as counsel and the families until the day of the transfer, and while the transfer was in progress, is, with respect, troubling. Given my role as counsel for the past 3 decades, it was incumbent of CSC to relay this critical development to me in a timely manner so that I could inform the families. This was not regular administrative news. A development of such pivotal importance came as a shock to the families and ought to have been processed through counsel. Had anyone considered that this transfer was done just over 2 weeks prior to the anniversary date of Leslie Mahaffey's abduction and murder? Does anyone at CSC appreciate the devastating grief experienced by the Mahaffey family at this time of year? While the timing could not have been worse, to effect such a transfer without any explanation, under the cloak of protecting privacy rights of the person who sadistically and brutally sexually tortured their daughters before murdering them, is beyond comprehension. As stated above, as counsel for the families, my discussion with CSC took place after the transfer, not prior to. This aside, if the families were informed of the transfer in the morning of May 29, with it being completed by early afternoon the same day, assuming that Mr. Bernardo was transferred in a secure vehicle and considering the distance between the 2 prisons, Mr. Bernardo was likely already in transit. Therefore, to issue a news release that the family, but not their lawyer, was informed prior to the transfer is misleading and disingenuous. Further, CSC had to know, or ought to have known, that the trial appellate lawyers like me are busy and often in court, and therefore leaving it to the day, I lost my place for a second, leaving it to the day of the transfer to contact counsel was highly problematic. We would therefore appreciate answers to the following questions. Who were the persons that were involved in the decision-making process to transfer Paul Bernardo? Who ultimately made the decision? Who had to sign off? If you were if you were not part of the decision-making process and you were unaware of the decision, how could such a decision with significant implications be kept from you? What exact time did Mr. Bernardo depart from Millhaven? What exact time did Mr. Bernardo arrive at La Macasa? Based on media reports and CSC statements, I am assuming that references to the offender's privacy relates to subsection 8.1 and 2 of the Privacy Act. Subsection 8.2 MI authorizes you to disclose the information where, in the opinion of the head of the institution, the public interest in disclosure clearly outweighs any invasion of privacy that could result from the disclosure. If this is the section that you are relying upon, we ask whether this analysis was undertaken prior to the transfer, and if so, we would respectfully request a copy of CSC's analysis, under this subsection. We also need to know if CSC applied the invasion of privacy test stated in the Treasury Board Secretariat use and disclosure of personal information for the purpose of its subsection 8.2 MI analysis. Our view is that that is unlawful, as in, contrary to the Privacy Act, the CCRA and S2B of the Charter, Section 2B of the Charter. Members of the public have a right to information pertaining to public institutions without which public confidence in the integrity of the administration of justice will be undermined. In my extensive experience in multiple cases, CSC and PBC play mere lip service to the Section 8.2 MI analysis, with the result that in 100% of cases, the decision favors the offender's privacy rights over the public interest. We urge you to restore public confidence in the correctional system and the administration of justice by rescinding the transfer order and return Mr. Bernardo to Millhaven. He is Canada's most notorious and dangerous serial killer who must face the full consequences of his sadistic and cowardly acts. This will also spare the families the need to travel to La Macasa, Quebec, rather than Millhaven, Ontario, for Mr. Bernardo's upcoming November 2023 parole hearing. Mr. French is 92 years of age, and this would be a significant burden. I would be pleased to discuss this at your convenience. We understand that Ms. French provided you with the writer's cell phone number.
I believe if Mr. Jennings had a point, he would have made it by now. It seems he has so little regard for the merit of his motion that he won't let it come to a vote. I would encourage him to do so, to let us vote on the matter and proceed.
Thank you, Mr. McKinnon.
Okay, thank you, Chair. Not a point of order. But look, I think I've been very clear about our position here as Conservatives. We believe that this issue of the prison transfer is critical and should not be, as the government has shown they clearly wish to do, buried.
I just wanted to correct the record, as my integrity was questioned by Mr. Genuis and suggested that I lied about or exaggerated what had happened. So on March 21st, 2024, at approximately 9:30, Mr. Lloyd asked a question of Commissioner Duhaime of the RCMP, and then said, with that, Mr. Chair, with Ann Kelly sitting right here in this room, the Conservatives pretending that this is a priority for them, only to filibuster, then said, with that, Mr. Chair, I would like to quickly move to a motion that I gave notice of last committee, and went on to move that motion on a carbon tax motion. And then now to pretend that this is a matter of importance because they don't want to discuss a bill that they claim to support, that Mr. Genuis, I'm sure, has gotten up in the House to support, is shocking. And then to suggest, having not been here, that I'm exaggerating what happened when it's clearly in the record, that their priority is whatever it will take to delay this committee. And they will use whatever, be it a crime, be it horrific facts, be it something horrific that happened to a community, they don't care. It's about chaos, it's about delay, and it's not about hearing about the witness. It's not about protecting children from child pornography.
Point of order, Chair.
It is genuinely shocking
Point of order.
what is happening.
Point of order, Mr. Genius.
Yeah,
Thank you, Mr. Biddle.
just my point of order is that Mr. Biddle is misusing points of order to prepare social media clips or perhaps audition for other positions within the government.
Point of order.
But I
Point of
would
order,
like to be
Mr.
able
Chair.
to
Point of
actually
order.
have points of order be
Mr.
related to
Mohammed,
rules and
please.
get back
There
to
are
the
two
substance.
things now. Now, two things I would like. One is he's impugning the credibility of another member. That is unparliamentary. Decorum is indeed in the standing orders an expectation requirement of all of us participating in committee proceedings. Mr. Biddle very clearly articulated what took place in that meeting, which ran counter to the assertions made by Mr. Genuis. He should withdraw those assertions without reservation, and let the business of the committee continue as it should. But this notion of decorum, this notion of not impugning and putting words into the mouths, if we want to be specific, of other members, particularly when the record has been clarified, I think is really important.
Thank you, Mr. Mohammed. Thank you, Mr. Biddle. Mr. Genius, can we stick to your topic, please, and continue with your letter? Thank you.
Thank you, Chair. I do have some substantive comments I could make in response to Mr. Biddle's intervention. I don't know that they're relevant, but I maintain my view that I didn't ever accuse him of lying, which implies a malicious intent. I do think he sometimes has, let's say, rose-colored glasses in the partisan sense, and that informs his recollection of certain events. So I am happy to discuss actually what happened at the meeting of March 21st, 2024, but I will hold off on that. Mr. Biddle might want to intervene, but it's probably not a point of order, so I will continue. So there are a number of things that were going on in the letter.
Sure, there's one on file.
Mr. Biddle, your mic was turned on there, so I was.
Point of order, Chair.
Thanks.
Point of order. This would go so much more smoother if Mr. Biddle would refrain from talking over my colleague, Mr. Genuis, when he has the floor. If he has something to say, perhaps he can point of order. But it's a constant distraction. I'm sitting literally 10 feet away from my colleague, and with Mr. Biddle's interventions, I can't hear what my colleague is saying. And I think and he's doing it again. So perhaps a little bit of decorum, Chair,
Thank you.
would be
Thank you,
very
Mr. Brock.
helpful, okay, for the efficiency of this meeting. Thank you.
Mr. Genius, please continue. Point of order, Mr. McKinnon.
Point of order. As this meeting seems to be winding down, I'm wondering if we could get unanimous consent of the committee that the committee request an extension of 30 sitting days for the consideration of Bill S-210, and that the chair accordingly present a report to the House. I should think, considering the importance that our conservative colleagues seem to place on Bill S-210, that doing a proper study should be most acceptable to them. So I'm wondering if we can get unanimous consent for such a motion.
No, there isn't.
Fortunately, Mr. McKinnon, you didn't get unanimous consent. Mr.
Point
Mohammed, point of order.
Mr. Chair. Unanimous consent is not required. You need the majority of the committee, so I'd like to move to recorded vote on this so that we can then continue with Mr. Genuis'
that's not
conversation,
correct.
which he
That's
seems
not
to think
correct.
is so important and more important than online harms.
On a point
Mr.
of order.
Genius?
Yeah.
Thank you, Mr. Mr. Mohammed. We'll continue, Mr. Genius.
Thank you.
It doesn't.
There are about 15 different standing orders that you propose to violate all at once, Mr. Nur Mohammed.
Point of order, Mr. Chair. Point of order.
You're
Mr.
right.
Chair.
It wasn't 15. It was probably
So,
3.
Mr. Genuis is yet again, impugning the credibility of members opposite. Number one. Number two. in a situation where they purport to care about a piece of legislation while they are clearly filibustering it, why would we not just move unanimous consent and move this forward? So again, I would ask that we give unanimous consent for the extension that has been sought so that we can have this. If they're serious about a conversation about S210, let's do it, because it's clear that Mr. Genuis is here to run down the clock and not do much else.
Thank you, Mr.
I'll just
Mohammed.
continue,
I'm
Mr.
asking for unanimous consent.
No unanimous consent for anything.
Continue, Mr. Genuis.
Thank you, Chair. And I'm going to come back to the prison transfer issue, but I want to be clear because Mr. Nur Mohammed and others are suggesting things which people can verify as inaccurate if they simply consult the minutes of the last committee meeting and of this committee meeting. We have moved a motion to resume consideration of the seventh report of the subcommittee and an amendment that I have put forward. The subcommittee includes a proposal for an extension on the bill he has mentioned. We have not proposed to make any changes to that request for an extension. However, we have proposed to amend the subcommittee report to also insist on a separate issue that the committee report on the transfer of Paul Bernardo. Liberals would rather have, I suspect, a very extended study of anything else to avoid completing the work that was started on the Bernardo prison transfer. So if members would like to deal with these items together, that is what the mechanics of the subcommittee report are designed to allow for. But we will insist, in that context, that
Point of order.
the Bernardo prison transfer issue be addressed as well.
It's whether we deal with them, altogether. I think what's important that we get to deal with them at all.
Point of order.
I'm speaking.
I'm raising a point of
I
order.
am speaking.
Let him finish, please.
But it's
I've been
not a
very
point of
generous
order.
with everybody.
It's not a point of order, very clearly.
I am speaking, and it's not your decision.
It's the
So-
chair. That's why I'm asking the chair to intervene because
Don't
you're
interrupt
breaking the
me.
rules. Point of order, Chair.
Don't speak over one another, guys.
I have a
please.
point of order.
Mr. McKinnon, is it in relevance?
I thought so. I was just wanted to point out that I would like to point out that the matter that Mr. Genuis seems to be promoting, that we should go and take up a certain order of business, we'd be in that order of business right now if we could actually come to a vote on his motion to do so. We would have been in this order of business 20 minutes ago, dealing exactly with what he purports to want to deal with. But he persists and persists and persists and talking out the clock so we don't actually get to make a decision.
Thank you, Mr. McKinnon. Mr. Genuis, you had a point of order?
Yeah, Chair, just on a point of order, I suspect that the intention of the government is to try to move things in camera and not have transparency around these discussions. But just on the point of order,
Mr. Chair.
Would there be unanimous consent to deem the motion I have moved adopted?
Point of order, Mr. Taleb, please, or Mr. Muhammad.
It would be wonderful if, in the rules of order which respect decorum, that Mr. Genuis not make implications or assertions as to what our position is or our views are. Again.
Thank you, Mr. Muhammad. Mr. Genuis,
Yeah.
continue.
With all due respect, there are parameters of decorum. There are certain things that members cannot say about each other. But he said something that I didn't find very nice is not a matter of order. There are principles and rules that establish how we operate. And Mr. Nur Mohammed, you are not the chair, and the chair has not sustained, I think, a single point of order from. Yeah, that's correct. That's correct. Anyways, you're not on the mic, so us having a conversation is probably not very, very productive from the perspective of.
We get back to Mr. Genuis.
That's correct.
So what you're-
But sorry, I had heard that there might be an appetite to adopt my motion. So if there's unanimous consent to do so, then I'm happy to give that unanimous consent for my motion to be deemed adopted. But I also know that when I finish speaking, there is a significant risk that Liberals will try to move in camera and bury discussions of these issues. So I certainly don't want to see that happen either. And as I said, Conservatives will use the procedural tools that we have available to us to insist that the committee report on the Bernardo transfer. So members can reflect on whether they want to continue to try to hide the report on the Bernardo transfer or whether they want to allow that work to happen. So I'm happy for my report to my motion to be adopted by unanimous consent if that's the will of the committee, or to proceed to make the substantial arguments that I would like to make with respect to the Bernardo prison transfer. And look, this would inevitably this would go faster if it wasn't for the repeated interruptions. So having read the letter from Tim Danson, I want to highlight, like there are a few different things going on at the same time with this issue. There was the question of the transfer itself. There was the question of information that was shared or not shared. But what I want to comment on just first is the sort of broader principle of victims' rights within our justice system.
Just for clarification, we have reached 10:15. So I'm just seeking clarification here because ordinarily this is the time that we would be ending our meeting.
Mr. Chair, although we have reached our normal termination, I would appreciate being able to vote on this matter before we adjourn.
Thank you, Mr. McKinnon. We do have resources until 10:30.
Chair, point of order.
Point of order, Mr. Shipley.
I would just like to ask the committee if this motion could be adopted by unanimous consent, then we can move on.
No? Do you want to, just hold on, Mr. Janius. Mr. McKinnon, do you want to be clear on what you're asking? Are you asking to vote on this motion?
Yes, I'd like to vote on this motion before we adjourn.
So I have the floor, and I'm going to continue, but Mr. Shipley has proposed that this motion be adopted by unanimous consent. But okay, yeah, then I will continue. It's either way. So I want the motion adopted. So if the motion's not going to be adopted, then I'm going to continue.
I'm confused now. Point of order.
Point of order, Mr. McKinnon.
It's clear that Mr. Dennis does not want this motion to be addressed by the committee. If he did, he would accept a vote at this time. We've all heard his hour and a half of points of irrelevance. There is no merit to any of his arguments, obviously, or else he would come he would let us vote on this matter. I encourage Mr. Dennis to have the courage of his motion and let us vote on it.
Thank you.
I'll ask the committee one more time. Are you willing to vote on this motion at this time?
There was I have the floor. There was a request from Mr. Shipley for unanimous consent
Yes.
to adopt the motion. Does the committee agree that the motion be adopted?
Mr.
Okay.
The
Well, then
point of order.
I'm going to keep talking.
Mr. Chair, you asked if the committee is prepared to vote on this. I believe there are a number of us who nodded in the affirmative, and you don't need unanimous consent to
has the
call the
floor.
vote. So
Yes, you do.
Let's vote.
Yes, you do. Just point of order. Like, Mr. Newmarhoud, it's no disrespect to you, but there are some. No, like not all of us are experts on everything, and that's fine. But I would just commend to you the reading of the standing orders, the specific sections around committees. The chair cannot call a vote just because he wants to, or just because one member has had enough of the debate. And the chair knows this very well.
Mr. Jenius?
And that's why he's the chair.
There was a request for a vote, so I asked everybody. You said no.
Yeah.
So we're going to continue.
If
So you continue.
if I can respond, Mr. Chair, to what he just said.
Go ahead, Mr.
The chair asked, would the committee like to vote? The majority of members in the committee said, yes, we would like to vote. That was in response to the chair, not to you, not to your UC motion. The chair asked if we would like to vote on it, not if we gave UC. There are two very different things. So I'm not a dummy. I understand the difference between UC and the request for a
Chair,
vote.
point of order. I haven't piped up a lot here for 2 hours, and you've been very liberal with your points of orders, but I think we're really straying away now to debate. And if we could maybe just finalize up. Mr. Jenius is bringing up some very valid points here, and I'm enjoying his dissertation here, and if he could keep going on that, would be great.
Shipley. Continue, Mr. Genius.
Thank you. Thank you, Chair. I thank the members for their good wishes. But I was actually very shocked by Mr. McKinnon's comment to say that these arguments had no merit. Regardless of what he thinks of me,
Point of order.
I was reading.
Point of order, Mr. McKinnon.
I did not say that they had no merit whatsoever. I said they have no merit to your to the motion you proposed. I'm ready to vote on that motion, whether or not we should, do as you say. It becomes moot the longer we go in this day because there's no time to do anything. But I think that if Mr. Jenius had any courage and any respect for his own motion, he would let us vote on it after speaking to it for an hour and a half.
Chair, point of order. Point of order.
Mr. Shipley?
We are getting now into personal comments and insults, and I really don't think that's appropriate. Maybe Mr. McKinnon
Point of
would like to
order.
take those back.
Mr. Shipley, thank you.
There was no personal insults in there. I just don't believe he has any regard for his own motion, or else he'd let us vote on it.
Thank you, Mr. McKinnon. We'll leave it there.
No
Mr.
personal
Shipley,
insults,
we'll
but-
leave it there. Mr. Genius, can you continue and be very specific of what you're speaking about, please?
Yeah,
Stay on the
thank-
motion.
Thank you, Chair. I was blessed with a thick skin, so we'll just continue. Look, Mr. McKinnon does not, although he's tried to qualify that since, but he doesn't appear to think that the arguments I've raised have merit or relevance, and that's fairly surprising to me for him to be so dismissive of the arguments that I had raised. Because
Point of order. I did not say they had no relevance whatsoever or merit whatsoever, but in relation to the motion before us, they're not relevant. They don't matter to this particular motion. The question is, does Mr. Jenius want to go to the motion he proposed, which is to go to a specific order of business and deal with these very items, or not? He seems to have little confidence in being able to do that. Otherwise, he'd let us vote on the matter.
Mr. Genius, please continue.
as I was saying, the member opposite has dismissed these substantial arguments that have been made as either not meritorious or not relevant to the question of the Bernardo prison transfer.
Point of order.
Which is...
Mr. McKinnon.
I made no reference to whether they were relevant to the Bernardo transfer. They are not relevant to the motion that is before this committee at this time, which is to go to a specific order of business.
And that specific order of business is the Bernardo transfer.
No, it's not.
Yes, it is.
Mr. Genius?
Yeah.
Are you done, Mr. McKinnon?
God, I hope so.
That might be
Mr.
something we
Genius,
can get unanimous
you have the
consent
floor.
on. Chair, I'm gonna, at risk of getting accused of repetition, let me say it again for Mr. McKinnon's benefit here. This is a motion to proceed to consideration of a particular item. Therefore, the nature of that particular item is central to this discussion. It is not in the general ambit of relevance. It is directly on the bullseye of the target of relevance. What we are talking about is proceeding to consideration of an amendment, and that amendment is about the Bernardo prison transfer. And as I have said very clearly, and I hope members have heard me on this, that Conservatives are insisting, will insist, and will use the procedural tools that allow us to insist, that we complete the report on the Bernardo prison transfer. That, like the information about the prison transfer itself, that this is not something that can be buried again by politicians who are not sufficiently concerned with the right of victims to know what is happening in cases that are relevant to them and to have their voices included. It is profoundly disrespectful to the witnesses that we heard on this subject to suggest that that their views are not meritorious or relevant, or to suggest that them having made the effort and gone through, I suspect, the challenge and the pressure of testifying, that somehow the committee could receive that evidence but then do nothing with it. I think that's offensive and wrong, and I think members of the public would expect that the sacrifice and the effort that went into providing that testimony lead to substantive reports and recommendations from the committee.
Point of order.
Point of order, Mr. McKinnon.
So let's vote on it. Let's get to the matter at hand and vote on these matters, so we can instead of talking about the issues and around the issues and beside the issues, let's deal with the issues.
McKinnon. Mr. Genius, please continue.
Thank you, Chair. I think my point having been made, and I think made clearly about the process that is before us, I will just proceed to making a couple key points that reflect my views in relation to the letter that Mr. Nansen wrote, that I have read, though it has been a few minutes since I finished reading it. Chair, this raises issues about the transfer itself, about the information that was shared, but I think most foundationally this raises important questions about victims' rights, about what we owe to victims of crime. Of course, recognizing universal human dignity, recognizing that every human being remains a human being, regardless of their circumstances or their actions. Our society justly recognizes that certain rights should be accorded to all people everywhere, and that recognition of rights needs to guide our operations of the operation of the criminal justice system, and there is, of course, a place within that for recognition of the rights of accused and, if convicted, the rights of offenders. But there has for too long, I think, been a lack of emphasis on the dignity, the experience, the rights of victims within that equation as well. And conservatives in government and in opposition have consistently sought to elevate that recognition of the rights of victims. What do we owe to victims? Of course, foundationally, we owe to victims that we make every effort to prevent them from becoming victims in the first place, and to prevent others from being victimized. That is a foundational importance. But when someone has been a victim of crime, in addition, I think we owe them the opportunity to have a voice in the process, to be able to share what happened, and to seek justice through the law. And that pursuit of justice involves them having a voice, having information, and having the justness of their desire to participate in conversations around the crime that happened to them or their family members. And I think often what we see from this NDP Liberal government is a real kind of casual dismissiveness towards the idea that victims have rights in this process. Of course, they have a right not to be victims in the first place, and they have a right to voice and information when they have been a victim. A victim doesn't have a right to determine the outcome of a proceeding, obviously, but they have a right, I think, to be a part of that proceeding. And so what happened in this case, I think, it demonstrated a callous disregard for that right, that role for victims to have a voice in proceedings. Mr. Danson highlighted the lack of respect shown for victims, the lack of consideration for the impact on them associated with certain timelines and significant dates, the lack of an effort to provide information in a timely way in a way that allowed them to share concerns that they might have, and a lack of engagement of their counsel in a way that would have allowed that information to be conveyed to them in a timely and appropriate manner. The fact that in the middle of a busy workday, a kind of nondescript voicemail was left with the lawyer looks
Point of
like.
order.
Point of order, Mr. McKinnon?
I have second thoughts on my decision to support Mr. Jennis's motion that is now on the floor by unanimous consent. I would now give that consent.
Okay.
Okay, so there's unanimous consent for my motion to be adopted?
I only note that I have reflected upon it, and I would, in my case, give this consent.
So that's you. Okay. So we're not being asked for unanimous consent, but only an opinion from Mr. McKinnon that he would now give unanimous consent.
I did hear Mr. Biddle say no. He's not at the table, but I think he still has the rights of a member since he's not in the room. So are we adopting it on unanimous consent, or is Mr. Biddle saying no? Or was it a staff member that said no? Well,
Let's make this official, Mr. Jenius. Are you asking for unanimous consent?
Is there unanimous consent for the motion to be adopted?
Is there unanimous consent for the motion to be adopted? Please continue, Mr. Jenius. You have about 30 seconds.
Point of order.
30 seconds till
Point of
what?
order, Mr. Biddle.
Let's vote on it. Mr. Genuis wants us to come to a vote. Let's vote.
I think my position was clear. I wanted it to be adopted.
Point of order, Mr. Chair.
Point of order, Mr. Norhabat.
If Mr. Jenius believes